Hello, my name is Tara Jacobs, and I am a member of the Massachusetts Governor's Council. I'd like to introduce a two-part panel discussion called the Pathway to Pardons. The first panel is made up of the decision makers along the process from receiving an application for pardon to the final determination of granting a pardon in Massachusetts. You will see members representing the Advisory Board of Pardons, which is the first step and is comprised of the same people who make up our parole board in Massachusetts. You'll see members of the governor's legal office who are in the next stage of evaluating applications for pardons and making recommendations to the governor. And then you'll see me and my fellow governor's counselor, Paul DePalo, who represents Central Massachusetts District 7. And we represent members of the council who together make the final determination on granting or not applications for pardons and commutations. To that point, there will be a QR code that comes up on the screen. I encourage you to scan the QR code. It takes you to a web page with many resources and links and useful information about the pardon process in Massachusetts. The first link is the PDF for the application for a pardon. Download that, print it out, fill it out, and send it in to Governor's Council as the first step in applying for a pardon in Massachusetts.
Let's dive on in. Our very first panel, our first of two panels, is made up of the key decision makers in each stage of the pardon process. And we're going to explore who is eligible for a pardon. We're going to talk about the governor's clemency guidelines and the process for applying for and receiving a pardon. We'll also talk about the criteria that the decision makers, all of whom are with us here today, or most of whom are here with us today, at each stage of the process, and what it is that they use in order to determine whether or not to grant a pardon. So let me introduce our first panel's speakers to you. First, we have, immediately to my right, Keara Kelley, who is the lead legal counsel of the Parole Board and Advisory Board of Pardons. And Keara will share her insights into the role that the Advisory Board of Pardons plays in reviewing applications, holding hearings, and making recommendations to the governor. Next, we are so honored and privileged to have with us Paige Scott-Reed, who is the governor's chief legal counsel, and seated just directly to her left, Adam Hornstine, who is deputy legal counsel and soon to join my former ranks on the Superior Court. They're going to share from their perspectives their role in reviewing the pardon applications that they receive and advising Governor Healey in the pardon process. And then we have Governor's Council members, Paul DePalo from District 7 and Tara Jacobs, who you've already met from District 8, who will talk about their roles, that is to say the Council's role in granting pardons, along with their important perspectives and the process that they go through in entertaining the pardon applications that come before them for review and for approval. So let's dive right on in. Governor Healey released a set of clemency guidelines, I believe it was October 31 of last year, that describe how she views clemency as a tool and the reasons that the governor hopes to grant pardons. And these clemency guidelines have nationally been been referred to as a major shift from prior administrations. They have been described as the most carefully crafted and justice-oriented clemency guidelines in the country. Let me first turn to Adam, to Paige, and we're going to go on a first name basis, although you can call me Judge Mason. Only kidding. Can you help us understand, Adam and Paige, the viewpoint that is expressed by these guidelines and the impact that the governor intended to have in their utilization? And also talk a little bit about what the term compelling need is, as is set forth in the guidelines. So Adam, I'll turn it over to you.
Thank you so much. When the governor issued these new executive clemency guidelines last October, it was the Healey Driscoll administration's goal to use clemency as a tool to soften the sharper edges of the criminal justice system. As reflected in these guidelines, the governor affirmatively wants to use her power of clemency in the form of pardons and commutations in order to address historical injustices, to foreground compassion in the administration of criminal justice, and to promote equity and fight racism that has pervaded the criminal justice system. To that end, the governor has exercised this clemency power and applied these guidelines with that compassionate lens in mind to move along and to recommend to the Governor's Council many pardons during the first now almost 2 years of her term. One thing that these guidelines focus on, as have been focused on in prior iterations of guidelines from previous administrations, is the idea of a compelling need. And frequently we get asked, I know Keara has been asked in her role at the advisory board, what does that mean? What does it mean for somebody to demonstrate a compelling need for clemency relief, a compelling need for a pardon? I think this may be a question later about how these guidelines differ from other prior iterations or prior administration's guidelines, but suffice it to say, these new guidelines took a deliberately broad view of what a compelling need would be. This is because the Healey Driscoll administration recognizes that criminal convictions have profound collateral consequences for people who have been convicted of crimes. It affects people's ability to get jobs, people's ability to get housing, people's ability to reintegrate into society. And fundamentally, convictions carry their own stigma, their own weight. And we want, as an administration, to address those things as broadly as possible through these guidelines. So when we are talking about what somebody needs to demonstrate to show a compelling need for a pardon, understand that we want to take an affirmatively broad view of what is required to obtain clemency relief. So I will punt it over to my boss, Chief Legal Counsel Paige Scott-Reed, to see if I have messed anything up or if she wants to augment the answer in any way.
You never mess anything up, Adam. But I do want to add a few thoughts really about why new guidelines and what's the philosophy behind the changes that you see in this new set of guidelines. And for that, I think the most important point for us was that clemency is not sort of a sidelight or a little extra. It's an important part of the criminal justice system. This governor and this administration believe that we are not done with the criminal justice system when the court makes a ruling and somebody is convicted. We're not done when a person is incarcerated. We're not even done when they have served their sentence and been released back into the community. The criminal justice system should be aiming to have that individual reintegrated into their community and functioning well and successful. And so if you take that long view of what the criminal justice system is, clemency is an important part. It's the part that is intended to recognize when someone has changed over time, when they have grown over time. We're not the same person 30 years later as we were 30 years before, and the criminal justice system should recognize those realities. So when a petition for pardon or commutation comes in front of us, we are principally looking for what has changed over time. What has this person done since they were convicted? How can pardons or commutations help to ensure incentives for reintegration and easing of the burden of reintegration? So that's the sort of like highest level philosophy behind the changes to these guidelines is to bring pardons and commutations into a robust view of the criminal justice system as a whole, rather than to see them as a weird historical fluke that the governor kind of has the opportunity to do at the end of a term. We view clemency as part and parcel of the criminal justice system, and as important as many other parts of the system. And then also wanted to talk a little bit about the imperfections in the criminal justice system. These guidelines try to explicitly recognize that as hard as we try, the system's not perfect. And there are injustices that happen in the course of the criminal justice process. Pardons and commutations are one opportunity for the governor to recognize places where there have been imperfections and to try and increase the amount of justice that there is in the criminal justice system. So we take quite seriously the new language in the guidelines that talk about systemic injustice and that talk about the role of the governor in issuing clemency to try and right wrongs that are now visible to us. So I just wanted to add that sort of philosophical gloss to what it is that we're trying to do in this process.
Thank you very much. First, let me state thank you for the recognition that your office and the governor have given to not just recognizing that justice transcends sentencing, which is candidly, that was my world for 15 years. Not just recognizing that it transcends sentencing, but pervades throughout an individual's lifetime, but actually doing something practical and important and impactful about it. So thank you very much. The Governor's Clemency Guidelines, along with a number of other materials, are linked into that QR code right there. So when you get a chance, make sure that you download it to your phone or whatsoever. There's a wealth of information apart from the guidelines, including resource material that we'll be discussing. Let's move on. I want to talk about eligibility. Who is eligible for a pardon? So let me turn to Keara, to you, and perhaps Adam, to talk about the eligibility guidelines.
So the short answer is that anyone who has been convicted of an offense by a court in Massachusetts is eligible to apply for a pardon. If the Advisory Board of Pardons receives an application from someone showing that they have been convicted of such an offense, and we have enough information to sufficiently identify what the offense is from the materials that are provided, the advisory board is going to review that petition and make a recommendation to the governor. There are also a couple of guiding principles in the guidelines about eligibility, but none of these would disqualify anyone from applying. For example, the guidelines do say that pardons are usually reserved for an individual who has demonstrated a substantial period of good citizenship. And the recommendation is that it would be 10 years in the case of a felony conviction or 5 years in the case of a misdemeanor. However, this isn't a requirement. The advisory board certainly will still review a petition that doesn't meet that standard, and I don't want to speak for the governor's office, but I'm sure they would also review it as well when it comes to their desk. And there's also a recommendation in the guidelines, and I think at some point we're going to discuss briefly the difference between a pardon and a commutation. But there is a recommendation that those who are serving a sentence of incarceration currently generally would seek commutation before seeking a pardon. But again, this is not a hard and fast requirement or something that would disqualify a person from applying for a pardon if they were still serving a term of incarceration.
All right, Adam, if you can chime in, and following up on Keara's comment, can you talk about the distinctions between a pardon and a commutation?
Absolutely. This is, again, a question that I know Keara and I field a lot. A pardon has the effect of removing a conviction from somebody's criminal record. It is, in effect, the state of Massachusetts saying that this offense is no longer on your record. It's no longer part of your criminal conviction background. A commutation, by contrast, leaves the conviction on your record, but it modifies a sentence. As Keara was saying, most commonly, this is sought by people who are currently incarcerated and wish to modify their sentence to either get out of prison immediately or to be released to parole. So that is fundamentally what the distinction is. And as Keara correctly observes, for those people who are currently serving their sentences, the guidelines do presume that it would be a commutation petition first before a pardon. That all being said, I know that both the advisory board and the governor's office consider any petition that is properly before it, regardless of how it is styled.
Great. There will be time for questions at the culmination of the panel. So if you have a question, I believe that someone may be handing out cards. If not, you can simply tell us what your question is, but we'll have some time at the end of the panel. So let me ask you, Keara, is it ever too soon after a conviction to apply for a pardon?
So again, the short answer would be no. There are those recommendations in the guideline that typically a pardon would be reserved for someone who's demonstrated that substantial period of good citizenship, but it's not a requirement. The petition wouldn't be disqualified if it were sooner than that.
Right. And are there certain convictions which would be inappropriate? That is to say, would certain convictions exclude you, per se, from pardon?
No, a pardon petition can be filed by anyone for any type of offense that they've been convicted of.
Okay. And the guidelines contain a bit of a, I won't say it's a laundry list, it's not that, but, criteria that are taken into consideration. Can you talk a little bit about those criteria and the flexibility of meeting those criteria?
Do you want to address
Adam?
that? Sure.
Again, as Paige emphasized earlier, we really these guidelines were drafted as broadly as possible to encourage people to apply, and as part of, again, viewing this through the lens of compassion, and as part of the continuum of the criminal justice system. As a result, a lot of these guidelines have suggestions and recommendations for things that petitioners may want to demonstrate. However, I want to emphasize, again, I know the moderator characterized this as a laundry list of factors that will be considered. These are designed to be guidelines. They are not black and white hard rules. So we are looking, when we evaluate applications, for example, to see whether somebody has a demonstrated period of community service or good citizenship, whether somebody, has addressed via restitution in victim crimes, whether they've been working with factors such as that. But again, I want to emphasize that these guidelines are designed to be very broad, and these factors are not an exclusive list. Again, as Keara emphasized, I think that it's important to realize that we are looking to cast a broad as net as possible to find out who, should have a petition evaluated and who should have their petition considered and granted ultimately by the governor with the approval of the council.
So the concept of sealing records, we don't need to get into expungement, and pardons seems to be different concepts, okay? That is to say, there may be interplay, but they are distinct, procedures. If someone has a sealed record, would their application for pardon perhaps be viewed differently because they already have a sealed record? So, Keara?
No. I mean, I can say from the perspective of the advisory board, that is not a factor that's considered. Whether the conviction appears on a sealed record or an unsealed record, the petition would be considered the same way and go through the process the same way.
And you know what? I presided over the Springfield District Court sealing session for 6 years, and it was a wonderful experience, perhaps the only experience, which was a joyful experience for all involved. But let's say that your application for pardon is allowed. Does that mean that your record is automatically sealed, or do you still need to petition for sealing?
Typically, if a pardon is recommended by the governor and approved by the council in the normal and ordinary course, under statute, we would then recommend that the case be sealed without the additional need for judicial intervention. There is one caveat to that, however, which is that earlier this year, the governor used her pardon power to pardon possession of Class D offenses, so possession of marijuana offenses. Sort of automatically, and again with the approval of the council, because those people did not affirmatively step forward and ask for a pardon. We have encouraged those people who want to have their record sealed as a result of that specific pardon to file a request for it's called a pardon certificate with our office, with the governor's office, and through that form, there's a checkbox that could say, please also seal my record. So with that one exception, sealing sort of automatically happens for pardoned offenses. And maybe now that I'm thinking about it out loud, we could add this to the website, the link for the marijuana pardon form. That may be a good idea to do on the back end. So,
Yeah, and the devil's in the detail, and perhaps counsel or individuals would best be advised to check their record, even if they think it has been sealed, because the Office of the Commissioner of Probation or whatever have you, it may not have made it to through the process quite yet. All right, let's shift gears. I'd like to go right down the line and have each of you talk about your role in the process. And so perhaps we'll take it in, I suppose, kind of chronological order. We'll start off with Keara from the perspective of the parole board, which takes on the role of the advisory board of pardons. Then we'll go to the governor's legal office with Paige and Adam, and then to Tara and Paul on behalf of the governor's council.
So the Advisory Board of Pardons initially receives any petition for clemency, either a pardon or a commutation, from the Governor's Council office. So initially the petition is filed with the Governor's Council office and immediately forwarded to us at the Advisory Board. We're required to notify certain agencies that may have an interest in the petition. For example, the Attorney General's office, the district attorney that prosecuted the case, a local police department, if the person's incarcerated, the Department of Corrections. So we send out those notices. And with that, we ask for documentation about the offense. And we also ask for those individuals to provide any input that they may wish to give about the petition that's been filed. Once all that information is received, it's gathered together along with the petition and anything that came with it, and it's presented to the advisory board for an initial vote. And the board decides by a majority whether to conduct a hearing to collect more information and hear from the petitioner, or to not conduct a hearing. If the board votes not to conduct a hearing, we send notification to the governor's legal office, and that is considered an unfavorable recommendation by the advisory board. If the board does choose to conduct a hearing, that hearing is scheduled in the normal course. And then the Advisory Board of Pardons will sit at that hearing, which is open to the public, and it's recorded. At the hearing, the petitioner comes in and answers the Advisory Board's questions about the offense, about what they've done in their lives since the offense took place, and any other topics that the board may find relevant to the decision of whether to recommend a pardon or a commutation. Petitioners may bring up to 3 supporters to speak on their behalf. Sometimes there are also opposition witnesses who come in to speak, for example, on behalf of a victim or a family member or one of those agencies that may have an interest in the petition. The advisory board collects all of that information from the hearing and then conducts a second vote. And at that time, they're voting whether to recommend, again by a majority, a favorable or unfavorable recommendation of the petition to the governor. The board puts together what's called a report and recommendation, and that is a synopsis of all of the information that was received and reviewed, as well as the board's recommendation to the governor. We forward that on to the governor's legal office and anyone else that may have an interest in the petition, and from there it's in their court to make the next decision.
All right. So, Adam and Paige?
So the process in our office starts with Adam, so I'm going to let Adam do most of the talking. But the most important thing to be aware of is that despite what the board recommends, our office takes a new look, and we can recommend a pardon to the governor even if the board has recommended a denial, and vice versa. If the board has recommended a pardon, we're not bound to also recommend that to the governor. But Adam, do you want to talk a little bit about process?
Yes, I'd be pleased to. So the first thing that we do, excuse me, whenever we get a report and recommendation from Keara and the advisory board is we review it with fresh eyes. It is essentially for the lawyers in the room, de novo, fresh look of the recommendation. And we will evaluate all of the materials that are submitted up through the advisory board to us, letters of support, letters in opposition, victim statements, statements from prosecutors, statements from members of the community. We will conduct our own research in many instances to look into the petitioner, their crimes, and their community works to get a better sense of who the person is. And it's a very holistic process. From that point, I will prepare for Paige a memorandum that summarizes all of the facts, all of the legal history, and applies those facts and that legal history through an analysis of the executive clemency guidelines. And it is at that point that Paige, in consultation with other members of the governor's legal office and governor's staff, will make a recommendation to Governor Healey. And then ultimately it is Governor Healey who makes the decision to recommend a pardon or a commutation be approved. And if that is the case, it goes to the governor's council.
Okay. All right. Very well. So now the petition arrives at the governor's council. So either Paul or Tara, whomever wishes to speak first.
So the governor's council is the final step, and there's 8 councillors, and we're elected. So the first thing to remember is there is a political angle to this, and so although no one pays attention to the governor's council, we need a council that's supportive of clemency in order to actually make these things happen. And so that can take many roles, obviously the final vote, but there's advocacy to be done as well, and advocacy is contextual. I was first elected under the prior administration. To their credit, in their final year, they did issue 3 commutations. When those were being discussed, I know Councillor Terrence Kennedy and I, Councillor Jacobs wasn't yet on the council, visited the gentleman in our correctional facilities, wrote op-eds, but we were a very small part of the village that was advocating. There's folks in this room, attorneys and otherwise, who are a big part of making that part of the public discourse and ultimately leading to those commutations. And then the other thing to consider is that the council is the final threshold. And so while under the Healey-Driscoll administration, we've been very grateful for the Legal Counsel Office approach to clemency, the way the clemency guidelines have been manifested in actual issuance of pardons. But I think the public in general, when they think about pardons, sometimes think about, especially on the federal level, pardons issued at the end of a term that might be politically motivated, friends of the outgoing administration. And so the council, in those rare occasions, and I trust it won't be under this administration, is a threshold that prevents those kinds of pardons from happening and kind of perverting the system. And there was an instance of that happening under the prior administration. So those are that's some of the overarching ways that we impact the process.
All right, Tara.
Yeah, so I am in my first term, and I've been very lucky to be with an administration that very much values using clemency as a tool to course correct our justice system. And so that's the perspective I bring as well. We, as a council, the way that we work, we each represent a district. And so in the same way that when there are judicial nominations, that reside in our district, it's similar for the pardons. So pardons that originated in our districts come to us kind of to make the decisions about how to proceed. And so again, we are each elected and we each come with our own flavor of how we do our work. So there isn't a single answer onto how council operates. It's very much counselor to counselor. In my instance, it is possible when we receive pardons from the governor in our district to decide to hold a hearing at council. And that has happened. And it's an option available to us. Personally, I prefer not to hold a hearing on a pardon because my feeling about pardons is that they are designed to really remove the stigma, the shame, the burden, the barriers that a conviction create in a person's life. And so I don't want to add to the newsprint around it. So what I do though is I as my part of my process, just to share, I do talk to each applicant on the phone. I have areas of focus that are important to me. I really want to hear reflected back that, and I'll step back a second to say I very much value the input of the Advisory Board of Pardons. I trust the work that they do and the report that we get. It is a very comprehensive look, and I put a lot of emphasis on just sort of trusting their opinion and that of the governor's office. Having said that, I do want to see some things. I want to know that, this is a person who has availed themselves of their second chance. They're on the course to continue to be productive and positive members of their community. And that granting a pardon is that final step to really unburdening them to be fully able to thrive. And that's the criteria that I am primarily using in my own approach to clemency work.
All right, great. So apparently there is a methodical defined process that is reflected in all that you've stated. What is the source of the grant of pardons? Because it has a constitutional basis. Okay, so Adam, you want to, to prove that you can serve as a Superior Court judge, you want to take that one?
Sure, no problem. Thank you. So yes, there are two primary sources of the governor's pardoning power. The first is contained in the Constitution, the state constitution itself, which affords the governor, subject to the advice and consent of the council, with the constitutional authority to issue pardons and commutations. However, in addition, for all felony offenses, the Constitution also affords the state legislature the ability to prescribe certain procedures and steps that must take place through a pardon petition process. And that is all contained in statute. Much of what Keara was talking about with sort of the avenue of how the advisory board reaches out to certain parties to solicit information, how the advisory board collects that information, holds hearings, and considers pardon applications is actually what is prescribed by statute. So although there is the constitutional prerogative afforded to the governor, again, subject to the advice of the council, much of the procedure is actually outlined by legislative enactment. And I think those citations should all be in the guidelines, to the extent that any practitioners in the room actually want to double check my math on this.
So what influences, external influences, either political influences or a Netflix series influence, might come to bear on any decision making, if any? So let's go right down the line. So, Keara, from your perspective.
I'm going to defer on that one.
Yeah.
At least from my vantage point, and again, subject to others' input, none. We view every petition on its own bottom, on its own merits.
So I'll add to that a little bit. Reference has been made to the fact that this is, at some level, a political process because the power to grant has been granted to a political actor in the governor and the governor's council. And I highlight that because the political process is good at a particular thing, and that is gathering input from the community and being responsive to the overall, I hate to use the phrase will of the people because I think it's overused, but the to take into account what does the community feel about how we want to behave as a community. So this process does accept those inputs, and our office is very willing to listen to individuals or advocates who want to talk to us about particular applications that are in front of us. And I know the Governor's Council feels the same way. It's not that the decision is based on political power. It's that as responsive political servants, it responds to the input that comes from the community. And what that means for advocates is that your role is important. If there is a petition in front of us, hearing from you can often make a difference. And folks do that in different ways. Sometimes folks call us, send letters to the governor, send letters to the governor's council. All of that work is important in trying to shift the system in the direction we want to see it go.
Great. Tara and Paul.
I'll just add to that, you know, I started off by saying how important this work is to me. The clemency work is probably the most meaningful and impactful. And because of that, I'm very protective of it. And I am aware of history where clemency work has been derailed by, you know, there's always a risk inherent. And clemency work in the past has been derailed by bad acts from those who have been granted, you know, be it a pardon, a commutation, or a furlough. And the political consequence of that can be extreme, and the backlash can really shut down the work. And so it's part of how I approach it is to do my best to be protective of it, and that we grant pardons to those who are deserving and who we believe will make the most of it, and be as attentive as possible to red flags. So as much as I want to see an influx of pardon applications, I think it's important just to be realistic that not every pardon application will get granted a pardon, but that I hope that we will be doing a lot of this work, and that the people who receive it will make the most of it.
Paul.
Just want to add one thing. So all of us, whether we're elected or advocates in this space, are political actors. And so as Councillor Jacobs was just alluding to, when the narrative, the public discourse on an issue like clemency shifts radically as it did essentially in the presidential election when Governor Dukakis was a nominee, it's important to shift that public discourse in the other direction. And so, again, the advocates in this room, there's, you know, I know on the council, and before Councillor Jacobs was there, some of the councillors, hopefully to good ends, used the occasion of parole board appointees and the hearings they had before the council to talk about, at that time, a lack of clemency hearings happening, the reasons why clemency was important, and using that opportunity to kind of bring the issue up, bring the issue to light, and also to kind of remind the past administration that this is something that that's an important part of our justice system. And so the need for that hasn't been present under the current administration because Governor Healey campaigned talking about clemency, which was amazing, and executed the things she had talked about on the campaign trail. And of course, as we've heard, the Legal Counsel Office has been incredibly supportive of making sure this becomes a routine and not an exception to how we function as a system.
Excellent. Thank you all very much. We have a few questions that have been previously submitted, then we'll open the floor. I want to thank our panel for keeping us right on time. And from my perspective here, I can see that lunch has arrived. So I will spend a couple of moments with some questions. Question number one, perhaps for Keara. How many pardon applications have been filed since Governor Healey took office?
So what I have available are the number of petitions that have been filed during the last 3 years. So I can say that in 2022, the advisory board received 61 total petitions for executive clemency. 42 of those were for pardons and 19 were for commutations. In 2023, the advisory board received 60 total petitions for executive clemency. 29 of those were for pardons and 30 for commutations. This year, 2024, to date, the advisory board has received 99 petitions for executive clemency. 41 of those are for pardons and 58 for commutations.
Okay. So out of curiosity, do the Department of Corrections or any of the sheriff's departments provide any assistance, legal or otherwise, for individuals seeking clemency? And this might be a question for our second panel, but anyone here have any information in that regard? Okay, well, we'll pass that one on to our second panel, which perhaps is better suited. All right, how about this one? If a person has multiple offenses that they were convicted for, should the pardon be sought for all charges?
So that's really up to the petitioner. Some people file a petition and they only have one offense on their record, and that's all they're asking for. Some people have multiple convictions on their record, and they come in with a petition that says, I want a pardon for my entire record. On the other hand, someone might say, well, I know that I have 1, 2, 3 convictions, but it's really just this third one that's been the obstacle for me, that's preventing me from doing what I want to do, that's having immigration consequences or keeping me from restoring my firearm rights or preventing me from seeking the job that I want. So I'm really just concerned about that one. So that's really up to the petitioner. I know with the advisory board, sometimes we receive the petition and it's a little bit unclear to us initially if the person is seeking a pardon for just one offense or for every offense on their record. Our practice generally is when we receive a petition like that, we'll send an outreach letter to the individual asking them to clarify exactly which offense or offenses they're seeking a pardon for.
Okay. Any questions? Yes, sir.
Yes, hi, my name is Charles Stokes. I'm from Springfield. I'm the community protagonist. And so I wanted to ask a couple of questions. First is on people who have been convicted of murder and that have been out now like 10 to 15 years, been in our community working hard. Is there a stigma that could perhaps, or something political, that could stop them from, even if they have all the criteria fulfilled, could that stop them from being, getting a commutation? And also, those who are elderly, they keep getting denied parole and stuff. So the elderly that's in prison, what can we do to prevent them from, they're like a couple of guys in their 90s right now. They're still in jail. What can we do to get them out if they're not out? How do we help them get the commutation? And one other point, will you expunge, does this expunge the crime from their record if they get commutation?
So there are 3 questions, and our second panel is going to be talking about the particular issues that you raised. For example, medical parole, okay, for people who are elderly, who are incarcerated, talking about expungement or sealing of records, that sort of thing. And our second panel will address that. And so if we can reserve your question.
Can I
go ahead.
just a couple
Sure.
quick, I hate to leave it hanging, so just a couple quick things. These guidelines touch upon one of the questions that you asked in particular, which is, what is the role of clemency with respect to somebody who is elderly or might be ill in incarceration? The guidelines recognize that the primary pathway for someone like that is to request parole, and there's a process for seeking parole, but also leave open the possibility of using commutation as a way of addressing that element of the criminal justice system. So I think I want to be clear that this administration is open to using commutation to address a situation where a person is incarcerated and no longer feels just that that person should continue to be incarcerated, whether that be because of physical ailments or age, even though it continues to say that the primary mechanism is to request parole. commutation does not expunge a record. It alters a sentence. A pardon removes that conviction, so it follows from the removal of the conviction that then the record would get, it actually gets sealed rather than completely removed, but the effect is to remove the burden.
Yeah, Tara.
Just one of the questions that you asked was about consideration of a murder, whether or not we would, and I just want to sort of answer from my perspective at least, that for me it's not necessarily, and it may be different along the line before it gets to us, but at council at least, there isn't a specific type of charge that I personally would exclude. It's much more about on each individual situation who the person is, what the narrative is, the story of what actually happened, and to a much more important degree what's happened since, right? So there's the charge, but then there's what have you done with your life since then, and where are you? And I will say, at least so far, and we've had quite a number of pardons come through council during this term. It's remarkable how many, possibly all, I can't think of an exception, of these pardons originated when the person was a teenager, like an emerging adult, super young, like cognitive development not finished, impulse control still an issue, understanding consequences not a thing yet. And so, that's the kind of context that I'm looking at, and add to it what has already been alluded to, but the bias inherent in the system. So people of color who are over-policed and overcharged, people of the LGBTQ or disability communities who there's implicit bias we know in the system that impacted possibly how they were originally over-policed possibly, or overcharged and over-sentenced, and on and on. So those are the considerations for me, at least, and I only speak for myself on councils. We each are very different in how we do our work.
All right, I see we have one more question, and then we're going to have to move forward, and there'll be plenty of time for further questions. Many of the issues that we're discussing right now are the focal point of the second panel, and there'll be plenty of time for questions after. And I'm sure some of the other panelists will have a chance to speak with you, but you had your hand up first, Gary.
Thanks, Judge. My name's Gary Porter. I'm the co-owner of the African Diaspora Mental Health Association, so this is very close and dear to me. That being said, one of the first things that I actually heard was the governor's interest around race and equity. And that being said, as I look at the panel, I don't see much diversity on the panel. So I'm wondering what that looks like for the rest of the decision makers, one. Secondly, what implicit bias work has each of you done to mitigate these race and equity issues too? And number three is, as you go through the process and you're looking at the information, what are you doing to make sure that implicit bias is not seeping in? For example, redacting any information that relays the individual's race as you're making these considerations. Thank you.
Okay. Right. Why don't we just go down the road?
Maybe I could jump in on at least the panel composition, which I own some but not all responsibility for. I think some of the composition of the decision makers really rests out there in the audience with you, right? You elect the governor's counselors, and so we are thrilled that we are going to have some increased diversity in the ranks of the governor's council after the past election, but this takes a village. The governor has some ability to control or to influence the composition of the parole board, and this governor has been really intentional about trying to increase the diversity of that body, but also to address some of the things that I think you work on every day to ensure that the parole board has the professional experience to understand mental health, to understand the process of rehabilitation and the journey that folks with, for example, addiction experiences go on to try and recover from those conditions. So we are, I will say, quite proud of the work that we have been doing on that front. It's not complete, but it's certainly an issue that we are very much focused on. And then I think we could each talk about our own work on ourselves and our approach to bias. I think the one thing that I do want to sort of push back on a little bit is I don't think that the criminal justice system is blind to race, and I don't think it's possible to review clemency petitions blind to race. I think that the system is impacted by an individual's race as well as lots of other factors, and when we look at what happened to them and try and decide whether or not to recommend clemency, we need to understand that part of the system, and so we are not attempting to treat each application devoid of the race of the individual.